New concerns tonight about Supreme Court nominee Judge Sotomayor and her rulings on our Second Amendment rights. Specifically, can states and municipalities restrict our gun rights? That's the subject of our face-off debate. The Judges Court ruled the Second Amendment doesn't guarantee rights on the state level. And joining me now, Ian Millhiser from the Center for American Progress, who says the judge followed the Supreme Court's Second Amendment precedents. Also joining us is James Jacobs, constitutional law professor at New York University, who says her opinion was wrong. Good to have you both here. Professor Jacobs, we're talking about in this instance not guns, but nunchucks. Why do you think she erred in that judgment?
Well, I think that the right to bear arms and and in the Heller decision, it's a fundamental right. I think the court made that clear, and I think American history makes it clear. And I think that the Supreme Court, in months to come, or in the next term, or in the term after that, will rule that the First Amendment rights apply against states and municipalities.
All right, Ian Millhiser, your thoughts?
Well, I think the only thing we really know about Judge Sotomayor's decisions is that her Second Amendment decisions show that she knows how to follow the law. They're two very old Supreme Court decisions dealing with the Second Amendment. The first said there's no individual right to own guns, and the second one said that the Second Amendment doesn't apply to the states. The Supreme Court last year overruled the first one. They haven't said anything about the second. So the professor may be right that they're going to turn around and overrule the Second Amendment, that second decision, but until they do so, Judge Sotomayor did the right thing, which is to say, I'm a lower court judge. I do not have the power to overturn a Supreme Court decision, so I'm going to act properly.
That is precisely what the Ninth Circuit Court of Appeals just did recently. Let's take a closer look at the Second Circuit Court of Appeals decision. Judge Sotomayor, part of that three-judge panel, referred to the 1886 decision, Presser v. Illinois, to defend New York's right to prohibit certain weapons, saying, the Second Amendment applies only to limitations the federal government seeks to impose on this right. Heller, a case involving a challenge to the District of Columbia's general prohibition on handguns, does not invalidate this long-standing principle. Isn't that simply disregarding the Heller decision?
I don't think so. I think that when you have two Supreme Court decisions that deal with two different subjects, one is the subject of what is the right, and the other is the subject of who does the right apply to. Does it apply to Congress, the states, or both? A lower court judge simply does not have the power to overrule a Supreme Court decision. And so when the Supreme Court leaves a case in place, a lower court judge has to follow it. They have no choice.
I think that might be a little bit too strong about doesn't have the power. I think it was within her discretion and would have been, and that it would have been a reasonable decision to have taken the next step and to have applied the Heller decision to the states and localities, as the Ninth Circuit did, and did very persuasively.
Here is an expression from Judge Sotomayor as she signed on to a 2004 decision, U.S. versus Sanchez-Villar, in which the panel of judges declared straightforwardly, the right to possess a gun is clearly not a fundamental right. Ian, what do you think?
I think that's a function of the fact that that decision was in 2004, which was 4 years before the Heller decision. Heller changed the landscape. And so things that were true about the Second Amendment in 2004, when Judge Sotomayor correctly wrote those words, are no longer true because, again, she must follow Supreme Court precedent. And so before 2004, the Supreme Court has said that there was not a fundamental right under the Second Amendment. Now she has to work within the Heller framework, and that means that she has to follow that decision. I have every confidence that she will.
Yeah, I would agree with that. Before Heller, that was the mainstream position. But after Heller, everything has changed. We're really now just at the very beginning of jurisprudence, constitutional law on the Second Amendment. There'll be a lot of decisions facing the court in the next 10 years, and we'll see what Heller has brought.
Antonin Scalia wrote this: there seems to us no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms which was the foundation, of course, of the Heller decision and its impact. The decision seems absolutely clear, yet there seems to be a great effort within the courts and amongst some judges to make the Second Amendment something to obfuscate rather than illuminate, to dampen rather than give full force to that amendment as an individual and powerful fundamental right. Is that going to be the contest in the next several years before the Supreme Court?
Yeah, I think that's true, and I think that has been consistent with the whole 20th century jurisprudence on the Second Amendment, as the courts have been very, very resistant to recognizing an individual right to keep and bear arms, and we continue to see a lot of that resistance.
Ian, your thoughts?
Oh, and if I could just add, I agree with a lot of what the professor had to say. I think that Heller left a lot of questions open that haven't been decided. Heller, for example, said that the federal government can still ban guns in sensitive places. Now, is a bank a sensitive place? Is a street corner a sensitive place? Is a liquor store a sensitive place? There's all kinds of places where gun violence occurs, and we don't know yet what the Supreme Court is going to say about those places.
Yeah, and of course there is one very sensitive place, for example, and that's the city of Chicago, where there has been an extraordinary number of deaths and murders of young people in that city. Yet Chicago itself, one of the strongest, strictest gun control cities in the nation. This is an argument as between also legislation and the role of the courts as well, is it not, Professor?
It is, and so we face some important questions here about how much deference should be given to localities in making their own decisions, and how much the Constitution requires a certain solution here.
In Millhiser, the Bill of Rights, pretty precious. Should we permit the dilution of any of those rights?
I think we shouldn't permit the dilution of them, but again, the point I need to make about Judge Sotomayor is that she did not do that. What she did is she followed a Supreme Court precedent which said that the Second Amendment does not apply to the states, and until the Supreme Court overturns that precedent, that's the world that she had to live in.
Ian Millhiser, thank you very much. Professor James Jacob, thank you very much.